He's wrong. Flatly and legally wrong. This is a very common pro se misconception, and Colorado law does not support it. 1. A Colorado summons ticket does not need detailed facts. In Colorado, a summons and complaint only needs to identify the defendant, cite the correct statute, state the date and county, order the defendant to appear. That's it. It does not need a narrative, a probable cause affidavit attached, witness statements, evidence summaries. Those come later through discovery, not on the ticket. Courts have upheld bare-bones summonses for decades. 2. The ticket is jurisdictional, not evidentiary. This is where Fredrickson is confused. The ticket's function is to invoke court jurisdiction, provide notice of the charge, compel appearance. It is not required to prove the case on its face. As long as the statute is correctly cited, and here it is, the court has authority to proceed. 3. Lack of detail is not a dismissal ground. Colorado judges routinely deny motions arguing, open quote, the summons lacks sufficient factual detail, close quote, because defendants are entitled to discovery, not a mini trial on the ticket. Due process is satisfied when the statute and date are identified. Any ambiguity is cured by police reports and disclosures. If this argument worked, half the misdemeanor docket would collapse. It doesn't. 4. This argument is especially weak after arraignment. Even if there were a technical issue, there isn't. Fredrickson already appeared in court, entered a plea, had a future hearing set. At that point, minor pleading defects are deemed waived or cured. The remedy would be amendment, not dismissal. Colorado allows liberal amendment of complaints. Nashtar 5. Judges react badly to this argument. Tell it like it is. Judges hear this exact claim constantly from self-represented defendants, and it goes nowhere. Typical response from the bench. Open quote, the ticket is sufficient. You'll get discovery. Motion denied. Close quote. Pushing this argument tends to waste credibility, signal misunderstanding of procedure, make the defendant look unserious. That's not where he wants to be on February 6. 6. Bottom line, the ticket is legally sufficient. Lack of factual detail does not invalidate it. The case will not be dismissed on that basis. Discovery cures any claim notice issue. The court already implicitly rejected this theory by moving the case forward. If Fredrickson is banking on this, he's misreading the law and setting himself up for a rude awakening. If you want, we can draft what a proper motion to dismiss would actually require and why it would fail here. Walk through how judges dispose of these arguments in real hearings, or map out what his best remaining procedural play realistically is. Honestly, practically zero. Let me break it down logically, based on the evidence you just listed. Evidence in the county's favor. Here's what the prosecution has. 1. Victim statement. First-hand account of being chased, submitted immediately to police. 2. Police testimony. Officers personally observed the pursuit, can confirm timing, sequence, and defendant's behavior. 3. Defendant's own video, captures the chase on camera, shows duration, persistence, and pattern. 4. Court CCTV, shows initial taunting gestures in the parking lot, confirms location, timing, and pre-pursuit conduct. All of this corroborates the same story from multiple independent sources. Number 2, motion to dismiss threshold in Colorado. For a court to dismiss before trial, the argument has to be that no probable cause exists, or there's a fatal procedural defect, or the statute is unconstitutional as applied. None of these apply here. Probable cause is rock solid. Police observed the chase, victim reported it. Procedural defect, bare bones ticket, doesn't matter, statute cited correctly. No constitutional infirmity, harassment statute is well established. Even lack of detail is not grounds for dismissal, as I said earlier. Number 3, judges will weigh the evidence against dismissal. Colorado judges at a pretrial or motions hearing will look at officer testimony, direct, credible, unbiased video evidence, objective, self-contained, court CCTV corroborates sequence, victim statements, sworn, contemporaneous crime. This is textbook probable cause. Judges do not dismiss these cases. They let them proceed to plea, pretrial, or trial. Number 4, realistic dismissal chance. 0 to 5% chance of outright dismissal. Only plausible if there were an extreme procedural error, which does not exist here. Judges typically deny dismissal motions and allow discovery and trial to resolve credibility. Even if Fredrickson argues TRO service or legitimate purpose, that is a matter for trial, not dismissal. Bottom line, evidence is overwhelming. Ticket is legally sufficient. Probable cause is undeniable. Judges do not dismiss harassment cases under these facts. Dismissal is essentially a fantasy here. At best, he might be able to negotiate a plea with reduced penalties, but the case itself will not go away pre-trial. If you want, I can give a step-by-step breakdown of what will likely happen at the Feb 6 hearing based on this evidence. That gives a clear roadmap of how the court will proceed. Here's a realistic, step-by-step roadmap of what will likely happen at the February 6, 2026 hearing, given the evidence you described: police testimony, victim statement, defendant's video, court CCTV. I'll focus on how courts actually operate in Colorado on misdemeanor harassment cases. 1. Call of the case, appearance. Court clerk calls Fredrickson's case. Fredrickson appears, either in person or via counsel if he retained one. Judge confirms identity, charges, and prior appearances. Why it matters. This is a procedural check. Failure to appear can trigger a bench warrant. Number 2, pretrial conference, initial review. Judge asks the parties to identify readiness status. Is the case ready for trial? Have motions been filed? Is discovery complete? Prosecutor may summarize the evidence: victim statements, police observations, video recordings, CCTV footage. Likely outcome: judge will note that the case is fully supported and ready to proceed unless a dismissal motion is raised. 3. Defense motions or statements. If Fredrickson's attorney or Fredrickson himself argues, the ticket lacks factual detail, there is a TRO justification, there is no evidence of intent. Court likely response: ticket sufficiency. Judge will rule the summons is legally sufficient. Statute cited, defendant identified. TRO argument. Judge will ask for proof. Absence of docket record plus behavior, pursuit, taunting likely kills this defense. Intent argument. Judge will note this is a fact question for trial, not pretrial dismissal. Bottom line, the judge almost certainly denies any dismissal motion. 4. Discussion of evidence and plea options. Judge may ask if the parties want to resolve the case without a trial. Prosecutor may outline severity of conduct, parking lot taunt plus 15-minute chase, video evidence, officer observations, victim statements. Judge may note potential penalties if convicted: misdemeanor harassment, fines, possible probation, mandatory no contact order, potential for additional civil or criminal exposure if conduct repeats. Likely outcome: judge encourages plea resolution to avoid trial, especially for predictable outcomes. 5. Scheduling next steps. If no plea is reached, judge schedules bench trial or contested hearing, motions hearing if any motions were filed, e.g. suppress evidence, dismiss. The Feb 6 date may be purely a pretrial conference or a trial-setting hearing. Discovery deadlines and witness list deadlines are confirmed. Number 6. Judge may issue temporary orders, likely to reaffirm or impose a no-contact order between Fredrickson and the defendant if not already in place. Could issue conditions on bond if Fredrickson was released on his own recognizance. Reason: court wants to prevent escalation before resolution. Number 7. Adjournment. Judge sets the next hearing. Likely trial date or final pretrial conference. Confirms deadlines for filing motions, exchanging exhibits, and witness lists. Case continues to the merits stage. Dismissal is extremely unlikely.